Appeal by special leave. Powers given by Article 136 in the nature of a special or residuary power which is exercisable outside the purview of ordinary law in case where needs of justice demand interference by the highest court of the land. It vests in the Supreme Court plenary jurisdiction on the matter of entertaining and appearing appeals by granting special leave against any judgment, decree, determination, or order in any cause or matter passed or made by any court or tribunal except a court martial. Because the power under this article is a reserved power, it cannot be exhaustively defined. But the decided case prove that special leave is granted in exceptional cases where grave and substantial injustice has been made. An appeal directly from the order of the tribunal must be dismissed before the Supreme Court because Supreme Court does not accept in exceptional and special circumstances exercise its power under Article 136 of the Constitution of India in a way as to pass the High Court by entertaining an appeal direct from the order of the tribunal and thereby ignore the decision by the High Court. IT Commissioner Allahabad versus Lakhiram Ramdas, AIR 1967, SC 338. Supreme Court itself interpreted the significance of Article 136 in some decision in Haripada Day versus State of West Bengal, AIR 1965, SC 757. In Martu versus State of UP, AIR 1971, SC 1110, Supreme Court has held that under Article 136, the court will grant special leave to appeal only if there has been gross miscarriage of justice or if the facts of the case were such as were shocking to the judicial conscience of the people. In the next place, such leave may be granted against any order while under Article 132, it is confined to a judgment, decree or final order. Under Article 136, an appeal may lie even against an interlocutory order. In Messrs. Ganesh Trading Company versus Mojiram, AIR 1978, SC 554, the Supreme Court pointed out that court can interfere with the order of the interlocutory nature if it is in order to promote uniform standards and views to prevent previous failure of justice. In the third and most important place, and leave under 132 is confined to appeal from a judgment, decree or final order of the High Court only, while under Article 136 it extends to appeal from judgment etc. of any court or tribunal except court martial. That is, such court may be any court subordinate to the High Court or any body which is not designated as a court but exercise judicial function like the industrial or income tax tribunal. While the scope of Article 132 is confined to constitutional matters emanating from High Court judgment. This is Article 136, that is Article 136 covers all miscellaneous matters from inferior court and tribunal. In Bihar Legal Service Society versus Chief Justice of India 1986, it has been held that Supreme Court would normally not disturb the order of the High Court and it will be final. Supreme Court normally not disturb the order of the High Court and it will be final. The court will interfere only in the limited class of cases where there is substantial question of law involved, which need to be finally laid at rest by it for the entire country. And when there is a grave, blatantly and atrocious miscarriage of justice, Bhagwati suggested that it would be desirable to set up a national court of appeal to hear appeals in the court in civil, criminal, revenue and labor cases. Describe briefly the power, privileges and functions, appointment and tenure of Office of Comptroller and Auditor General of India. Article 148 of the Constitution provides that there shall be a Comptroller and Auditor General of India. The Comptroller and Auditor General of India shall be appointed by President by warrant under his hand and seal. He shall be removed from office on an address from both houses of Parliament on the ground of proved incompetence or misbehavior supported by majority of the total membership of each house and by a majority of not less than 2/3 of the members of each house present and voting. Such address must be presented in the same session. Welcome divine speech. So Article 148 stands for there shall be CAG, Comptroller. Comptroller and Auditor General of India shall be appointed by whom? By President. How? By warrant under his hand and seal. He shall be removed from office and on an address from both houses of the Parliament on the ground that incapacity and misbehavior supported a majority of total membership of each house and majority of not less than two-thirds of the members of each house and present in voting. Such address must be presented in the same session. Every person appointed to be a CAG shall, before he enters his office, make and subscribe before the president or some person appointed by him an oath or affirmation according to the form set out for the purpose in the third schedule. So third schedules, according to the third schedule, oath and affirmation, the CAG has to took oath and affirmation. Then only he can enter his office. The salary and other conditions of service of the CAG, Comptroller and Auditor General of India, shall be such as may be determined by Parliament by law, and until they are so determined, there shall be such as specified in the second schedule. So term and condition of service, salary and other conditions has been specified in second schedule. Salary of this Comptroller and Auditor General of India and his rights and privileges in respect of leave of absence, pension or age of retirement shall not be varied to his disadvantage during the tenure of the office. CAG of India shall not be eligible for further office under the Government of India or the Government of any state after he ceased to hold his office. After CAG ceased to hold his office, he cannot get office under Government of India, cannot eligible to hold office under Government of India or Government of any state after he ceased to hold his office. To maintain secrecy, I think. Subject to this provision of this constitution and any law made by parliament, the condition of this service so no, it is not relevant. Subject to the provision of this constitution, any law made by parliament, the condition of service of persons serving in Indian Audit and Accounts Department and the administrative power of the Comptroller and Auditor General shall be such as may be prescribed by rules made by President after consultation with Comptroller and Auditor General of India. Administrative expenses of the officer of CAG include salaries, allowances, pension payable to the person or in respect of person serving in that office shall be charged upon which fund? Consolidated Fund of India. Salaries, allowances, expenses, pension which is payable to the CAG shall be charged to Consolidated Fund of India, Article 148. Duties, powers of Comptroller and Auditor General of India shall perform such duties and exercise such power in relation to accounts of the Union and States or any other authority or body as may be prescribed by law or under any law made by Parliament until the provision in that behalf is so made, shall perform such duties and exercise such power in relation to accounts of the Union and State were conferred or on the Auditor General of India or exercisable by Auditor General of India immediately before commencement of the Constitution in relation to accounts of the Dominion of India and of the provinces respectively. Article 149 states that this particular thing. The accounts for the Union and the State shall be kept in such form as the CAG may on advice of the President prescribe. Audit report. The reports of the CAG of India relating to accounts of Union shall be submitted to the President, who shall cause them to be laid before each house of the Parliament, and reports of the CAG of India relating to accounts of the state shall be submitted to the Governor of the state, who shall cause them to be laid before the legislature of the state. Article 151 states that the reports of the CAG shall be submitted to President, and President would further submit it to the before the House of the Parliament, and the same thing related to accounts related to state would be submitted to the Governor, and some Governor would lay it to the legislature of the state. So that's all about CAG, and that's all about we have discussed about CAG and the special appeal by special leave. If you find it useful, like and subscribe my YouTube channel for more such legal content. Thank you.